So, like I said, welcome everyone. Hello, we're so glad that you are here today. If you are joining us because a loved one has recently passed, our condolences to you. Or if you are trying to figure out how to navigate probate and what steps to take next, you are in the right place. Today's webinar is all about giving you clarity and direction during what can feel like a really overwhelming process. And we'll walk through what probate is, what to expect, the steps involved, and how to avoid common and costly mistakes. We will also be touching on how some families are able to avoid probate altogether with the right planning. So this will be a quick focus session, about 20 to 30 minutes total. So you'll get the information you need without it taking up your whole afternoon. We're happy that you're here. And just so you know, we'll also be sharing a special discount on our services at the end of the webinar for those who do want help moving forward. And like I said, you'll see that chat box. Feel free to drop general comments there at any point. And if you have specific questions, feel free to use the Q&A box as well. We'll be monitoring that throughout this webinar and answering questions throughout and at the end. So I'll start off and introduce myself. I'm the marketing director and a paralegal here at Northwest Estate Plans. My name is Jessie. I run many of the free planning meetings, and my goal is to make this process feel simple and approachable so you can understand your options without feeling overwhelmed. And then our main speaker today is attorney Jeremy Wallace. Jeremy, if you can go and wave so people know which one you are. Perfect. Jeremy is our firm's probate specialist and has helped many families navigate the probate process with clarity and confidence. He earned his law degree from Gonzaga University School of Law and brings a very well-rounded legal background to his work, helping families understand exactly what to expect and what to do next, like he'll be doing with us today. We also have attorney Bryce Mackey joining us. If you can go ahead and wave, Bryce. Bryce focuses on estate planning here at our firm, and he'll be helping answer questions, especially when it comes to how to avoid probate and protect your family moving forward. He also earned his degree from Gonzaga and has extensive experience helping families prepare and navigate these important decisions. You will also hear from a paralegal of ours, Miranda Myers. She's right here in the black. And she works closely with probate clients and helps guide families through the process step by step. And she'll also be walking us through a little bit of the process here during the webinar. Like I said earlier, we can help any Washington resident here at Northwest Estate Plans. We have decades of collective legal experience. Our team helps provide clarity and peace of mind to you every step of the way. Like I said earlier, you can work with a licensed attorney here at our firm 100% online from start to finish. All meetings are held via Zoom. If you don't want to come visit us in person at the Wenatchee office, and we are a flat fee firm, you know the full price of everything before you commit to any payment. And we're one of the only law firms in the state that is set up so you can complete your entire estate plan remotely or probate process, including signing everything with a virtual notary right from your phone or computer. So I will go ahead and hand everything over to Jeremy, who will walk us through a presentation.
Great. Thank you, Jesse. Um, Let me pull up the presentation real quick. Okay. So, like Jesse said, I handle most of the probates that we do for our firm. And it's actually, I really enjoy helping people through this time. I tell a lot of my clients that this is one of the most unfair things that our society does for us, is that in a time when we're grieving and we're trying to figure out how to deal with the loss of a loved one, our society says, hey, guess what? Now you got to make really important decisions. So while our brains are all foggy, we have to make these decisions. And I love helping people through this because I've been through it myself, and so I understand how hard it is. And it's just a joy for me to do this. So, the thing I want to talk to you guys about first was the single most common question I get, and that is, do I need a probate? And you'll find with every attorney, the answer is always maybe, we'll see, you know? So, let's talk about it for a second. Um, so a probate, simplest form of probate is permission from a court to pay off debts and to disperse assets of someone who has passed away. That's basically all a probate is. Yes, it does get a little more complicated than that, but we're not getting into that because that's 3 years of law school. And I'm assuming most of you guys don't want to go to 3 years of law school just to handle one probate. So, um, now, the process, probates get started by filing petitions. And there's a few petitions that you have to file, or two of them, petition to admit a will, or petition to get letters of administration, and a petition for solvency. And basically, all that does is you're asking the court for permission to get letters testamentary or letters of administration so that you can take care of whatever the estate needs to be taken care of. Okay. So it's like I said, a lot of big words, attorney words, but we're not going to use them in here. Uh, and then that part, so when the court gives permission, they issue letters testamentary, and then you can use those to get into bank accounts, to give you permission to uh, put property in other people's names, to sell houses, put cars in someone else's name, whatever you have to do. You have to have those letters generally. And I guess I should explain the difference between letters testamentary and letters of administration. And it's really letters testamentary is what you get when you have a will, and letters of administration is what you get when you don't have a will. And if you want the fancy names, that's if you have a will, it's testate, and if you don't have a will, it's called intestate. And so you go through the process, you pay off debts, you administer, you disperse assets, money, whatever to the heirs, and then you're able to close the estate. And that's the nutshell, the process of probate in a nutshell. And my paralegal Miranda will actually go through it a little bit more when it's her turn. So now we're looking at where to start, right? So many times we get put in this position where somebody passes away, there's a whole house full of stuff, hopefully some important papers, but we don't know. And then we're thinking, okay, so do I have to do a probate? Like, where do we go from here? And the first thing to know about whether or not you have to file a probate is what kind of assets the deceased person had, right? So you're looking for anything that has investment accounts, life insurance policies, 401ks, anything that shows that they had open bank accounts, whether they're checking or savings, any kind of monetary accounts, and then seeing if they have anything that would indicate that there's real property. And by real property, that's a legal term, it's just houses and land. So if you have any of those things, gather them together because that's going to help you decide whether or not you need to start a probate. Then there's other things like cars, gold, silver, jewelry, stuff like that, that it's good to know an estimated value of, but they aren't necessarily something that's going to 100% determine if you have need to start a probate. And the other big thing you need to look for is debts. Did they have any kind of debts? And most people when they pass will have a cable bill, a light bill, maybe a mortgage. But the big thing you want to check for is, especially if they were in any kind of long-term health situation, is whether they Medicaid was paying for any of that, because that'll make a huge difference on how whether you need a probate and then how that probate goes. So always, when you talk to an attorney, come as prepared as you can with what assets they have and then what debts, if any. Okay, so this is my big question. I love asking this. Okay, so you got all this information, so what? Right? Why is that important? And it's important because the type of asset and its value can help determine whether or not you actually need a probate. So, for instance, we have the first one on there is investment accounts, 401ks, and retirement accounts. So, if that's the only asset, do you need a probate? Usually not. And the reason for that is that on each of these accounts, there's usually what's called a beneficiary designation. And whoever's name is written into that designation, they get whatever's in the account outside of probate. So if that's the only thing and there are beneficiaries designated in there, you don't need a probate. The second thing is real property. houses, land? The answer to that one's usually. Especially if the land and the person who passed away was a parent or sibling, then 99 times out of 10, you're going to have to open a probate on that. Now, if it's a surviving spouse, things get a little different. And there's other ways that we could possibly help you to get that property transferred into their name without opening a probate. And don't worry, we'll go more into that a little bit later. So the next thing is bank accounts. And that's a huge maybe. And if you ever, come to any of these kind of webinars, you're gonna get really sick and tired of the word maybe because lawyers use it a lot. But it's mainly because it depends on the facts of whatever you're asking us. So in this case, for bank accounts, if your name or is already on the account, then no, you probably don't need probate if that's the only asset. But if your name or nobody else's name was on the account, and then banks generally won't give you access to that account unless you have letters testamentary or letters of administration. So you'd have to open up a probate in order to even have access to the account. So cars, boats, trailers. The answer is maybe, kinda. And the reason why I say that is because, trailers aren't generally licensed unless they're of a certain size. So, you have your regular dump trailer that was used to take garbage or yard waste out to the dump. That one can be, sorry, that one can be sold outside of probate, just as long as you keep track of what you did. Uh, Now, cars and boats, things that have to be licensed, those are a huge maybe because lately, generally, you would have to go to probate to change the names on those cars and boats. But lately, I've been having a few of my clients come up and tell me that they didn't have to. They just took the death certificate down to the Department of Licensing, and Department of Licensing changed the name on the title. So that one's a huge maybe, and it's kind of a case by case. And we think that it depends on who you get at the Department of Licensing that day. So you kind of have to play that one by ear. Uh, Gold, silver, jewelry, those kind of things, maybe depending on the value of them. So if they're under $100,000, then no, you probably don't need a probate. We can help you take care of that without spending as much money. And but if it's over $100,000, then there's a good chance you're going to need to open probate, because usually, well, we'll give that a second. And then debts only. So if there's only debts and no assets, no, don't open a probate. That would be, in my opinion, a colossal waste of time. Because if there's no assets that the debtors can come after, or creditors can come after, then there's no point in administering that estate. They're going to write those off anyways, and you can't necessarily get, probably a bad analogy at this point, but blood from a stone. You just can't do it. So, uh, on those cases, you wouldn't need to file probate. However, most people have a mix. So it's never just one thing. It's always a mix of land and investment accounts. Most people have a car on top of having a house. They have a bank account, a savings or checking account. So then it gets a little more complicated on whether or not you need to open probate. But I will tell you that the default for Washington State is yes, open a probate. But there's always exceptions. So and then things get a little even more complicated depending on whether or not there's a will, because it's not just the assets and the debts that you have to think about, but especially in cases where there's no will, it's also the relationship of the heirs to the person who passed away that you have to think about. So this is another question I get a lot of, so I'm throwing it out there to answer it. People will come to me and say, "But I have a will, so I don't need a probate." And that's not true. Right? So a will doesn't control whether or not you have to open a probate. It mainly controls how debts are paid and how assets are dispersed, and who gets to do those, who the personal representative is. But once again, even if you have a will, you still have to go back to what kind of assets you have and how much the value of them is. And then the next question is, I don't have a will, so I don't really need to probate it, right? And I will tell you the same thing as the will. Yeah, you got to do a probate on most things, depending on, once again, the assets and the value of those assets. But you're still going through the same analysis, except when you add on another layer, because when you have a will, then it tells you where the assets go to. It tells you who's in charge of the estate. It tells you how taxes and debts are going to get paid, right? But when you don't have a will, then the laws of the state of Washington take over, and they start telling you how your debts are going to get paid, how the debts are going to get paid, who gets the money afterwards, and who can be in charge of the estate. And so it gets a little bit more complicated when you don't have a will. And I would put this down here that it says it's governed by law, right? So that what the deceased wanted doesn't necessarily matter if there's not a will. So, and I say necessarily matters because you can always make agreements between heirs, but the state says how that money gets apportioned out. So I'm putting in a little plug right here for my partner Bryce. Right, have a will. Talk to Bryce about a will because it saves a lot of trouble and a lot of headache for, further on. So
And it's easy to do.
yes. All right, so now we're gonna play a game. It's called See If You Know What I Know. So these are some situations that I kind of came up with that, they don't take into account everything, but they're kind of more general ones. So if a husband dies with a will, but the only assets are investment accounts with his wife named as the beneficiary, do you need probate? All right, Bryce got it. Okay. The answer is no, right? Probate is not necessary because, like I said earlier, on those investment accounts, they get, as long as there's a named beneficiary, someone's name is written on the line that says where the money is going to go to, those pass outside of probate. And in fact, very rarely do they even, if you have to open a probate, those very rarely even come into the estate. They just get, the company will just write a check to whoever the beneficiaries are, send it to them, and that's the end of it. Okay, so here we go. Wife dies without a will, and surviving husband's name is on a deed to their house and all cars. They also have a joint checking account and savings. It's a little more complicated. What do you guys think? Okay, Jesse got it. Yeah. You don't need a probate for this one because with the wife surviving husband's name being on everything, there's other ways to get give them 100% ownership of the house and the cars without opening a probate. And these other ways we'll talk about later, but they are generally a lot cheaper than going through probate. Okay, we got a few more just because I love playing this when I teach youth groups. This is my favorite game. So, all right, so here we go. Next one is that mom dies with a will, leaving everything to her partner. And by I say partner because it is not a spouse. Okay, she had a house and a car in her name and some expensive jewelry. Do you need a probate? Yeah, gotta have a probate. And the key here is like what I pointed out is partner. Because they weren't married, they're not a surviving spouse. And so the community property rules of Washington don't apply. And there's no real way to get things moved around, especially the house, without opening a probate. So um, generally, probate laws and favor marriages in the state of Washington. So it's much easier to get things done through if people are legally married than if they're not. But it can still be done. Okay, so the next one is son dies without a will, leaving behind several investment accounts, some with the named beneficiary and others without. Mom is the only member of his immediate family still living. Do we need a probate? Yeah, Bryce is going, yeah, yeah, yeah. So on this one, I agree with Bryce. It's kind of a gray area, but I put on here better safe than sorry. Probate, you're going to want to do a probate. And the only reason why I really say that is because if some of these investment accounts don't have named beneficiaries on them, then some investment firms will not give you access without having letters testamentary or letters of administration. So if you run up against that situation and they say you got to have letters of administration, then more than likely you're going to have to open up a probate in order to do that. Um, and the fact that there's no will, right, was that was kind of a red herring, right? This is just kind of, mom is the only living family member, so everything goes to mom. But um, that's my take on that. It's kind of a gray area, but when in doubt, it's better to file a probate because then you don't get in trouble later on. So, okay, last one. I'm gonna move this. Oh, oops, I didn't even get to read that. I was trying to move this screen so I could see it. Okay. All right, now everybody knows the answer. Okay. So the big thing here is the community property agreement. Right? If you have a signed community property agreement and your name, well, and you can get through, and you're a surviving spouse, right? Then you can generally, for land purposes, record that community property agreement with the county, and then that puts everything, all the land into your name. So it's a really great way and a pretty inexpensive way to avoid probate for a lot of things between married individuals. So something to keep in mind there. All right, so that was kind of a fun game. But I talked about earlier how there's alternatives to probate. And the first one is a small estate affidavit. And just so you know, that's the term most commonly used, but it's also called a few other things that if you want to Google them, have fun, kind of it'll make for an interesting read, I guess. But that's generally what it is. And those are used if there is no land, no houses, and the whole of the estate is $100,000 or less than $100,000. So there's a few things though that you have to do to do a small estate affidavit, and that's to actually fill out the affidavit. You have to attest, you have to basically say that you are the person who is supposed to inherit all the property, right? And so this, I guess, takes effect even if there is a will. So if there's a will that says that, yeah, you get everything, great. You do one of these, I mean, everything's less than $100,000. You do one of these, you take it to wherever you need to take it to a bank or to an investment company. They have you fill out an application, you give them that, show them the death certificate, and they will give you access to the accounts or close it out, write a check or whatever. Now, if there's other people who might be heirs, you do have to give them notice on this. But I mean, hopefully you know where they're at and it won't be that hard to do. All right, so the next way to do it is affidavit of lack of probate. And these are used to transfer property when they're a real property, so land, houses, and houses, when they are in a spouse's name and you're the surviving spouse. But there wasn't a community property agreement. So you have this, and then you record this with the county, and the property transfers over to your name 100%, and it helps with clear title. So one of the questions that I get is, well, do I have to do that? And I usually say, not right now, but you're going to want to do it anyways, because the whole thing with land is that if you go to sell it, you want a clear chain of title, because if you don't have that clear chain of title, a title insurance company may not insure your title, and then it becomes much, much harder to sell property. Mainly, and especially if the buyer is trying to finance it. So you always want to have clear title. So, I mean, it doesn't need to be done, the day after a loved one passed, but it needs to be done at some point so that you have clear title. And then the last and probably the most important way is good estate planning, right? If you can get some good estate planning, you can avoid probate. Uh, well, depending on the situation, forever, or at least in the short term. So you can use trusts, community property agreements to help avoid probate in certain circumstances. And that's where I think Bryce is going to put a plug in here in a little bit about that because he's honestly much better at those things than I am. So, and then the second most common question I get is, can I open a probate without an attorney? And the answer is yes, right? You can do anything I can do in the state of Washington. The only question is, should you do it? Right? My dad was always like, Jeremy, just because you can do something doesn't mean you should. And that's how I feel about most probates. There's a lot of rules, a lot of laws, a lot of deadlines you have to follow. And if you don't know where to find them, don't know what they are, you can get yourself into a little bit of trouble. And usually that trouble involves other people suing, other heirs suing you. And if you get a judgment against you, that can come out of your pocket if you're the personal representative or executor of the estate. So definitely my advice is always go with an attorney, and that's not just because I'm an attorney. That's just because I want to look out for you guys. Okay, so in closing, whether you should open a probate or not, good estate planning will get rid of most of the guesswork. All right. So you have a will, you have trust, you have community property agreements. Those things, if properly done, will take away all that guesswork. Well, not all of it, most of it, and make things a lot smoother and a lot easier after somebody's passing. And my other advice is always talk to an attorney about whether you need probate. Most do free consultations like we do, but even if they don't, it's probably worth an hour of their time, to talk to them about this because could save you hundreds of thousands of dollars, right, if you're doing this wrong. And so, I guess another way it saves money is that you may not need a probate. And if you don't, then there's no point in wasting money on it. So that's what I generally recommend is do that because it will save you a ton of money. I think the next thing is Miranda, I believe. So she's going to talk to you a little bit about the process of probate.
Yes. So when you work with our firm to go through probate, we've designed the process to be as stress-free and simple as possible during what is already a difficult time. So the first step is you'll meet with myself or Jeremy for a 30-minute planning meeting over Zoom. And in that meeting, we go over your specific situation, look at what documents you have, what you don't have, and then we can go through what options Jeremy described, if we need a probate, and if not, what's the best fit for you. So the next step is then you'll send us the will, if there is a will, and the death certificate, and we'll prepare all of the initial probate documents for you. Once those are all ready, we'll meet again for a virtual signing appointment, and then Jeremy will file those documents with the court on your behalf. Then, once those are filed, we work to obtain those letters testamentary if that's what's needed in your case. Whatever letters they are, we will get those from the court, and that gives you the authority to act on behalf of the estate. And then at that point is also when we'll handle any of the required notices. So from there, then we go to administering the estate, and that just means we're paying out any outstanding debts, properly distributing the assets according to the will, if there is a will, and if not, according to how the state dictates. So finally, once everything's all completed, we guide you through closing the estate and just make sure all the legal requirements are fully satisfied. And throughout that entire process, our goal is just to handle the legal complexities so that you guys can focus on family and what matters most. That's a quick overview of the simple process of working with us for your probate.
Great, thank you. Um, so this is kind of our standard fees that we charge for our services. The big one is opening the probate. That's a $3,000 flat fee, and then there's a $342 court filing fee that goes with that. And just so you guys know, we file everything in Chelan County. It doesn't matter where in the state of Washington you file a probate. You can file it in any county. We do it in Chelan County because it's generally one of the smaller counties. We can get things done quicker. We're just a stone's throw from the courthouse, so if anything comes up, we can go over and handle that. And we generally know what our judges are looking for in order to make this process as painless as possible. So that when we open the probate, that includes getting the initial filing of the documents, and there's quite a few of those initially, getting the letters testamentary, and getting an EIN if needed for the estate. And that's one thing I didn't talk about in my presentation, but most estates will need an EIN number from the IRS for tax purposes, for setting up bank accounts for the estate, and for other reasons. So we do all that as a part of our services. Uh, Now, these other ones, these alternatives that we had talked about, those are generally $500 per document. So if you need a personal representative's deed as a part of the estate, it's $500. And then there's also, if you look down here, there's whether you use us or not, there is a required $335 county recording fee. Oh, sorry,
Yeah, that's
I
for
messed up
deeds,
on
I
that
think.
one.
Yeah.
Yeah, you don't need it for the small estate affidavit. You don't have to record, so there's no recording fee. I just forgot to take that star off of there. Sorry about that. So those are our basic prices. Now there are some estates that get a little more complicated and require more hands-on. So sometimes those do incur an extra fee, but we always talk to you about that before we charge. We don't just say, "Oh, hey, they sent an email. I'm going to charge them to read this email." Like always, call us, talk to us, and we will talk to you about if it's going to be an extra charge or not. I personally don't charge, if it's a 10-minute read and a quick lookup or something, I don't generally charge for those. But if it's going to take a bit of my time, then that's when we need to start talking about how much it's going to cost. So, um, and
Okay.
then,
Yeah.
sorry,
Oh no,
that's
you're
Jess's
good.
turn.
Yeah, we're getting into the final few things. So here's the discount, everybody, that I was mentioning in the chat. So if you are watching on a computer, you can take your phone and turn it on like you're gonna take a picture and literally just point it at your computer screen to scan this QR code. It'll pull up a calendar where you can schedule your free consultation with attorney Jeremy Wallace to talk about your unique probate situation. If you have any additional questions today or you want to hire him, you can use that link. I've also put the link in the chat so you can click it right from that chat box. So if you are on your phone, just access it there. We are offering a $200 discount if you do end up opening a probate process with us. And however, that discount is only applicable if you book your meeting with Jeremy today to talk with him. So you don't have to meet with him and actually talk to him today, but just get your appointment on his schedule today. So that discount is available, and there's links in the chat to be able to access his schedule if you don't scan it right here. So we'll jump to the next slide, and Attorney Bryce Mackey will close us out with some bonus information.
Hi, no, and great job, Jeremy. I think it's on our side of things, I know this question says, how can you set up your family to avoid probate? And that is definitely one of the questions that we regularly talk with people about. The good news is that at least in Washington State, probate is actually not a difficult process, as Jeremy was just explaining, especially compared to other states. We have probably the most, if not one of the most efficient probate codes in the country. And so when we do the estate planning side of it, we talk about probate, and for most people, it's up to you whether you want to jump through some extra hoops as far as like setting up a revocable living trust or setting up a transfer on death deed for your property or other things that you want to do if probate is one of your primary concerns and something that you want to avoid. But it's also something that we talk through because we don't necessarily want to engage in fear mongering about probate in general. Okay. Because for some, going through probate is not going to be a difficult process, and it's not necessarily something that you need to spend a bunch of extra money trying to avoid. Some people, that is absolutely the case, especially people who have properties in multiple states and things of that nature. But that's something that we talk through with you so that you can try and make an informed decision on what's going to work best for you or for your family. But If probate is something that you're concerned about, something that you want to avoid, or you just want to make things simpler on your family, it's pretty easy to take care of. And for most people, it involves setting up something like a revocable living trust, which we can absolutely help with. So please don't hesitate to reach out to us. Again, our initial consults are free, and we work with people to kind of walk through that question of like, okay, do I just need to set up a will? Do I need to set up a trust? What are kind of the pros and cons with that, and do I how badly do I want to avoid probate? Or you may walk away from this today and be like, man, Jeremy just sounded like the nicest guy, and so who cares if I have to go through probate, because at least I'll be able to work with him, and I don't think that's a bad answer either. So anyway, let us know what we can do to help, and we would be happy to. Clint and I and Jeremy would be happy to help you kind of organize yourselves so that you just have some peace of mind and know what to expect and know that everything's going to be okay.
All right. As we are winding down, like I said, you can go in the chat. There's links to click on to schedule either a free estate planning meeting to discuss your personal estate plan, a will or a trust, with either myself or Miranda, the other paralegal here. Or if you have probate matters to discuss, you can also schedule to talk with Jeremy, and save some money on your plans. We'll jump into a Q&A. If I haven't seen any questions so far. If you would like to put them in the chat, either the chat box or the Q&A box. We have had one on the live stream on Facebook. We had someone ask, what if my family members are fighting about who gets what after my father passed? So, do you guys have an answer for this person? Does that question make sense for you?
Yeah.
Mm-hmm.
Do you want this one, Bryce? Or you want me to take it?
Sure. Go for it, man.
Okay. So first off, you kind of go back to the whole thing about whether or not there's a will, right? If there's a will, then what the heirs want doesn't necessarily matter, right? Unless everybody comes together and forms an agreement to do it differently than what the will says. But that doesn't sound like your case. It sounds like if they're fighting and there is a will, then it just goes to the will. And usually there are specific bequests that go out to people. So, you know, this everything in this bank account goes to this person, and then it has to be followed. And as the personal representative, you don't hold any liability after that if you follow the will. Now, if there's not a will and it's intestate, then you're kind of going back to how the state of Washington, what the laws say. And that one gets divided up by percentages based off of community property and separate property. And it gets really complicated. And that's generally where I see a lot of fights happening because there's no will. So everybody wants to, get their specific thing. And that's not always going to work. So as the executor of the estate, then you have the responsibility to follow the law, divide the estate as required by the law. And sometimes, and I'm not saying that this is this case, but sometimes that just means sell everything and write a check and disperse it how you need to, right? But generally, what I recommend is family is more important than money. So if you guys can reach an agreement about how to do disperse the funds or, administer the estate, then try that first because, yeah, family's way more important. But I don't know, you got any other advice, Bryce?
Yeah, well, I mean, I think the big thing is just making sure that I mean, this is the reason why we get our estate planning documents in place beforehand, right? I mean, it whether you've got you can't control whether you have dramatic personalities or problem children in your family, right? Like we don't necessarily get to choose our family all the time. However, um, having documents in place, really simple documents in place to outline who's in charge and how everything gets distributed, makes things significantly easier on whoever you've appointed to be in charge, right? Because then they are, like Jeremy was saying, they're kind of bound by what you say. And people can complain or kick and scream all they want, but they're really not going to have a leg to stand on if you've already outlined what to do. And that's part of the estate planning process is trying to simplify things and make things as clear and as clean as possible so that there really is no question what your intent is and how things need to be carried out. And so So it's really not a probate issue per se, but it obviously comes up, but it's more of an estate planning issue and making sure that you've got documents in place that will make things really smooth and easy to administer, regardless of how difficult your family is.
And sorry, as a PR, my last piece of advice is to document everything. So if any money that spend for the estate, any disbursements you make, any fees that you take, always document it because each heirs can ask for an accounting. And if you don't have everything documented, then you can get in trouble. And so keep track of everything. And also at the end of it, when you close it out and everybody's complaining because they didn't get exactly what you wanted, if it has to go in front of a judge, then you have documentation of what you did, and the judge can rule that it was reasonable and fair and close the estate. So,
All right, if you have any final questions, now is the time to enter them in. We are wrapping up. What I'd recommend for your next step, if you're dealing with probate right now or you need to get started, the best thing you can do is schedule a free guidance meeting with our team. We'll walk through your situation, answer your questions, and give you a flat fee quote. We've made the process really simple, and we're so grateful that you all joined us here today. Don't forget to take advantage of the webinar only discount that we mentioned as far as booking your meeting today, and then you can take advantage of that. All the scheduling links are in the chat. If you have any questions, you can always contact our team as well. We are just online, Northwest Estate Plans. And if there's no additional questions, we'll go ahead and close. I'd like to thank both Jeremy and Bryce and then Miranda for being on today and teaching us about these very complex topics. So hopefully we broke it down simple enough for everyone today. Thank you again for your time. We appreciate it, and we hope to talk with you soon, hopefully under positive circumstances with your family. So, all right.
Thanks, you guys.
Thank
thank
you,
you.
everybody. Bye.